Hello, everyone, and welcome to the Retirement Planners of America podcast, where we have more fun than a human being should be allowed to have when talking about all this boring financial stuff. And in this podcast, we're going to be talking about something that we've gotten a lot of requests to do a podcast about, and that is estate planning. And we consider estate planning the art of passing on to your greedy, unwashed, undeserving heirs the fruits of your labor. And by the way, I've been saying this for years. Please do not email me and tell me that your heirs are not greedy or they're not unwashed, okay? It's a joke. Maybe.
Retirement Planners of America, RPOA.com.
This podcast, we're going to talk about the basics. We're going to go through several of those things for you. Thank you for watching. I hope this video finds you healthy, wealthy, and wise. Before we get going, let me introduce myself. I am Ken Moraif. I'm the founder and CEO of Retirement Planners of America. And we're a firm that specializes in working with people who are in what we consider to be the most important decade of your entire financial life. And that's the 5 years before you retire and the 5 years after you retire. That decade is supremely important. The decisions you make during that period will affect your retirement for the rest of your life. So it's super important that you do it right, and estate planning is part of that, and we're going to get into it. So I'm going to bring into the fray Jeremy, my what is your actual position? What's your title?
A co-host, I think.
Co-host.
Yeah.
Yes.
Yeah,
okay.
yeah.
My co-host. I like that. Okay. So you're my co-host.
Yes.
So we've got a lot of requests, to talk with, to put together, and this is a whole series.
Yes.
Right. So we're going to be talking about the basics. We're going to talk about how to design your beneficiary designations. We're going to talk about different kinds of entities you can create, like trusts and family partnerships and all those kind of things. And then we're going to get into some exotic stuff and do some exciting stuff. So we're going to build a little bit at a time on all these things.
Absolutely.
But this podcast is the beginning, just to set the stage and the basics.
Yeah, there's too much to cover in one sitting. It would be a 3-hour long thing, and nobody's going to sit there and watch that.
Yeah, they will.
Well, maybe not about estate planning
well, that's
in
true.
one sitting.
That's true.
Yeah. We're talking about dinosaurs and aliens, maybe.
Oh, yeah, okay. We'll have to inject a few dinosaurs and aliens in.
Yeah. Great. Okay, so I think we should get started. When we're creating estate planning and we're trying to plan out how we're going to pass along assets, money, property, whatever it is, what is estate planning?
Yeah, I'll tell you, estate planning, I'll tell you what it's not. Estate planning is not a science.
Yeah.
It's an art. Because it's different for everybody, and how you do it, what you do is determined by your own circumstances. And a lot of times emotions get into it. Sometimes people don't like their kids, or sometimes they like them too much. New grandchildren, as in, my case, I've had some new grandchildren lately. So, it's an art, but there's a science to the art as well. So it's kind of a combination of both. But essentially, the way I look at it, it is passing on to the aforementioned greedy, unwashed, undeserving heirs the fruits of your labor in the least taxed, most cost-efficient way, so that you achieve the goals you want with the wealth that you've accumulated.
Yeah. Who would benefit from planning, passing on their goods that they've earned?
I run into people who think, well, I don't have enough, stuff to warrant doing estate planning.
Right.
And I think that's not right, because one of the things that happen, if you don't have, a will is estate planning.
Yeah.
Right. So when you sit down and you say, this is who gets what and when, you create guardianship documents, whatever those things are, that is estate planning.
Yeah.
If you don't do that, and you pass, then you die you die intestate. Okay, intestate means without a will. And if you didn't create one, guess who has one created for you? The state that you live in.
Yeah.
The government.
Right.
And let me ask you a question. Do you think the government has their best interest at heart, or do you think they have your family's best interest at heart?
I'm going to venture a guess that the state is going to get as much as they possibly can.
Do you really, you mean they wouldn't want to design it in a way that your family gets as much as possible and they get the least?
It's for the greater good,
Yeah.
Ken.
Oh, okay. So you do not want to die intestate. So really, if you have 2 shekels to rub together, you should do some estate planning. You should plan on who gets what and when, and don't die intestate.
Yeah.
Not a good idea.
Yeah. So if you don't do it, we've alluded to the state's going to get as much as they can, but what is the outcome? Let's say you have several children and grandchildren. You die intestate. What happens if you don't have a will?
Well, you could be setting the stage for a family war.
Yeah.
I know of a family where these 3 sisters in their 80s who had gotten along their entire life, a small plot of land in Kentucky that was not worth very much.
Yeah.
I think it was like $10,000. But because their father, who lived to be 100, he was a long-lived family. These people did not have a will, and 2 of the sisters wanted to sell the plot. One of the sisters wanted to keep it. It turned into a family war.
Yeah.
And these women, they're 80 years old. They've known each other. They've been sisters their entire life, and now they're at war with each other over a piece of land that has not a lot of money, but has a lot of sentimental value. One of them looked at it as an heirloom, and the other's like, we want to get rid of it. We want to deal with it.
Yeah.
So, you could create a family war. You could create the state doing stuff for you. It's not difficult to create a will. There are lots of ways of doing that. So at the very least, you should have a will.
Yeah. Okay. So a will is documentation that says, here's what I own, and this is where it's going to go. Are there any stipulations or I know there are stipulations. What are some specifics in a will that make it kind of binding and keep the state out of it?
Well, the mere fact that you have a will, in most cases, will keep the state from creating it. Well, if you have that, you're not intestate.
Yes.
So by definition, the state should stay out of it. However, it does depend on the state you live in. There is such a thing as probate, and we'll talk about a living trust in a minute. But if you go through probate, that's an indirect where the state may get involved, and that could create delays and cost and issues that families have to deal with in a time when they've just lost their loved one.
Right.
And they're not in a psychological frame of mind to be dealing with these things, and yet they're forced into it. So another reason why you should do your estate planning is to help your family to avoid having to deal with all this stuff when they're not in the frame of mind to do it.
Yeah.
And then also, they don't know what your stuff is.
Yeah, right. Yes.
Unless you're sharing with them every day, they don't know where all your stuff is and
Right.
and all of that. So if you haven't done your estate planning, then what's going to happen is they're going to have to go find it all. It's going to be delayed. Who knows? There's some stuff they never find, and then suddenly somebody does, and they sell it off in an estate auction. So it makes life easy for everyone if you take a moment and do your estate planning.
Absolutely. Okay, so we're kind of talking about wills. What is an AB trust will?
Ooh, AB trust will. So we're going now from just a basic will where you just say this is what I have, and this is who gets it, and when, and potentially how. When you start getting into the how you're going to get it, now you're talking about the next step in more advanced estate planning, and so there are tax laws, which we'll talk about in another podcast, with regard to when you pass money down to family members or to anybody for that matter. And there's actually a story about that one. So, back in the 19-teens, 1913, I believe, apparently there was a smoke-filled room where all these people in the government were gathering, and back then they smoked a lot. So it was like, it was like a fog-filled, cigarette-smoked room, and the guy in the back of the room, which we've come to know well, right? With the Coke bottle glasses, and he's got the pocket protector with the ink all over it. And he's like, guys, people are are accumulating wealth, and then we haven't taxed it all, and they're passing it on to their heirs, and we're not collecting anything on that. This is terrible. We can't have that. And so they came up with the estate tax. And they said, what has to happen here is we have to tax it when it goes from one generation to the next. This is super important. We got to get our pound of flesh. And so they created what then they said, but we can't tax every single dollar.
Right.
Because if we do that, then we'll have a revolution on our hands.
Right.
If every single person, when they die, they got their money has to go to the government, then we'll get voted out of office. So we can't have that. So they created what are called the estate tax exemption.
Okay.
And and that was this guy with the pocket, the Coke bottle glasses. He said, what we'll do is we'll have an exemption. There'll be a certain amount that you can pass on without tax, but when you get above it, boom, that's when the estate tax kicks in. And boy, you should have heard the cheering in the room. They were like, genius, genius.
A lot of cheering and then a lot of coughing.
Yeah.
Right.
Well, and teary eyes from all the smoke. But they carried the guy around the room. They were, this is, by the way, folks, Google it. This actually happened. And so there's the exemption. So the exemption is per person.
Okay.
Okay. Currently, it's pretty high, but it has been pretty low. That I remember early in my career where anything over $200,000 that was passed on to the next generation was subject to the estate tax, and the estate tax could be 50% of everything over that $200,000. So the exemption amount, the $200,000 back then, it's higher now, is what you want to try to protect. You don't want to lose it.
Right.
So, and how you could lose it is if, when I die, I leave everything to my wife. Okay, so we both have an exemption. Just for sake of argument or conversation, let's say that the exemption is $1 million. Okay, so I can pass on $1 million tax-free to my kids, and so can my wife. I die, and I leave everything to my wife.
Yep.
Guess what I didn't do? I didn't use my $1 million.
Yeah.
And I didn't pass on that $1 million tax-free. So now it goes to my wife. How much does she have?
$1 million.
She has $1 million.
Yeah.
My $1 million got lost.
Yeah.
So now when she dies, it goes down to the kids, but we've only used $1 million of the $2 million total exemption that we could have used.
Gotcha.
Okay? So that's where the AB trust will comes into play. So what the AB trust will says is that upon my death, what I want to have happen is I want my half of the estate to go into the B trust.
Okay.
The B trust. So now, by virtue of me putting my half into the B trust, and let's say that my half was $1 million, I've used up my exemption. $1 million went into the B trust.
Right.
The B trust is usually for the benefit of your spouse.
Yes.
Generally speaking, that's how it's set up. Your spouse can be the trustee, your spouse gets the money, the spouse gets to use it, but you've used your exemption. So now, your estate has been depleted, it's gone into that trust. My wife now has her $1 million.
Right.
Upon her death, it passes on tax-free. So now we've passed on $2 million tax-free, when before we would have only passed $1 million tax-free.
Yeah.
So what the AB trust will does is the B portion is the portion that we're using the decedent's estate tax exemption so we don't lose it.
Okay.
And then it could go on from there wherever you want.
Yeah.
The A part is the spouse's side.
Yes.
Which you can't control in this example because it's my wife's money.
Right.
It's half hers. Although there is some argument about whether my half is hers as well
Right.
or not, but
Right.
that's for a different day.
And I'm guessing this is not something I could write on a napkin, let's say, at a restaurant, decide this and say, this is my will, sign it at the bottom, and that'll be legally binding.
No, that's not a good idea. You don't want to be doing that.
Oh.
I mean, you could,
Right.
but not the AB part. You could do
Okay.
you could do a straight up will by hand. I don't know how
Yeah.
well it'll hold up, but
Yeah.
if it's the last minute and you don't have one, you could write something down and say these are my wishes.
Yeah.
And I don't want to be a lawyer here, but I think it might hold up if
Yeah.
you had witnesses and it got notarized.
Yeah.
But better to have a will.
Yeah.
And if you do want to make sure that you're using your exemptions, that you're creating trusts for your children, and you have other more advanced planning, now what happens is the A, B trust wills.
Yeah.
So, and one of the things about AB trust wills is they're not expensive. People would probably think, oh my gosh, that's probably got thousands and thousands of dollars.
Yeah.
Generally speaking, in the scope of things, they're not that expensive.
Yeah.
But if you take into account the value that they'll bring to your family, and the thing about estate planning is it's a totally altruistic exercise.
Yeah.
Because you're going to be dead.
Yeah. Right. Yeah. Yeah.
So you're not doing it for yourself.
Yeah.
I remember when my mother, God bless her, when she was on her deathbed, I said, Mom, she had done estate planning and all that, and I said, what do you want me to do? She had some stocks that she had owned her entire life, and she's partial to. I said, Mom, what do you want me to do with these stocks? She goes, Kenny, I'll be dead. Do whatever you want.
Keep them forever. No,
she's like, do whatever you want. I'll be dead. I don't care. At this point, it's my role in here is over.
Yeah.
So that's the advantage of having the AB trust wills. Now, once you've set up the AB trusts, then the next thing that you should consider are what are called dynasty trusts.
Okay.
So you have the parents up here.
Yep.
And so they've created the AB trust. So upon death, the A and the B trusts, the B trust is funded when the first spouse dies.
Right.
And then the second spouse has the A trust. The next level down is the kids.
Yep.
So when the kids inherit, what you might want to consider is that each one of them inherits into what's called a dynasty trust.
Okay.
And we're going to do a separate podcast on that one as well. But dynasty trusts are essentially a way that you can preserve the inheritance that you leave to your greedy, unwashed, undeserving kids for up to 100 years under current law. And it can protect it from estate taxes going down to your grandchildren. It can protect it from lawsuits, from bankruptcy, from divorce, all those kind of things. It hermetically seals the inheritance that your children receive for potentially 100 years.
Wow.
So it's a pretty powerful document. One of the few documents that lawyers have created that I think is a really good idea. So that would be the AB trust will. So you have the AB, B is for spouse, A is for the surviving spouse. Upon the death of the surviving spouse, then the B trust goes down into the dynasty trust. The A trust goes down into the dynasty trust. Structured properly for most people, you should avoid all estate taxes. Because the limits are pretty high right now. And that, for most people, should be sufficient.
Yeah. Okay. So are there any alternative options for a will?
Yes, there are. So I mentioned probate earlier.
Yeah.
Probate in many, like for example in Texas, probate is not a big deal, right? And probate can take 60 days and cost $500. So it's not a really big deal in a few states. Now, there are other states where it's a very big deal. And unfortunately, what happens in those states is that the court actually makes money off of the probate process. They get paid for that.
Yeah.
So, my view is anything that you pay for, you're going to get more of.
Yeah, absolutely.
And so a living trust can help to avoid probate.
Okay.
So if you live in a state, and let me back up. So a living trust is essentially a will substitute. Okay. So it does exactly the same thing that a will does. It says who gets it, when do they get it, how do they get it. The AB trust scenario that I described, you can do that with a living trust as well. So all of those things can be done. Okay. Just anything you can do with a will, you can do with a living trust. Okay. Which is why a lot of times people have living trusts that they don't need. Yeah. They could have just had a will and that would have been sufficient. Right. So, but the living trust, the main advantage of it is the avoidance of probate. Okay. So if probate is a big issue for you, if you live in a...
What is a probate?
Oh, I'm sorry.
Yeah, we didn't explain what probate is. What is probate?
Good question. So probate is basically where the estate, the court makes sure that your assets are distributed according to your desires. Okay. Okay. And so it's the family war scenario, where families are fighting over each, who gets what.
Enforcement of a legal document.
Yes. Yeah. And so it's basically to make sure that the desires of the decedent are enforced and probate is what does that.
Okay.
And like I said, in some states it can be laborious, it can be time-consuming, it can be expensive,
Right.
and you want to avoid that. I would say. In other states, it's not.
Yeah.
So depending on the makeup of your estate, how, if you have a lot of complicated stuff, or you have property in different states, or you live in a state where probate is a big deal, you may want to use a living trust instead.
Okay.
And the reason why is because a living trust is essentially, like I said, it's a will substitute.
Yep.
It's doing everything, but you're also pre-probating your estate.
Oh, okay.
Okay, so the probate has already been done by virtue of you creating the living trust, because you have to now put things in the name of the living trust.
Yes.
And that, people get intimidated by that. It's not a big deal.
Yeah.
But it's not something you should do if you don't need to.
Right.
But if you do, it's not a big deal to do it.
Right.
And so by pre-probating, right, you've already legally documented that this is how it's supposed to go and all that. You put it in a living trust. Then you avoid probate.
Yeah.
And it can be quick and easy in most cases. And so a living trust, and the other thing also about living trust that you have to be careful of is that a living trust is basically, it's you.
Okay.
Okay? It's not like an irrevocable trust, which we'll talk about in another podcast, but it has no tax ID number. It's your social security number.
Okay.
So it doesn't, a lot of times I hear you'll save on estate taxes by having a living trust. That's not true. What saves you is the AB part of it,
Right.
but you can do that without the living trust. You
Right.
don't need the living trust to save on estate taxes.
Yeah.
So that's sometimes in the marketing of those, I think, is a little disingenuous. But because it's you, right, it has your tax ID number. It doesn't save you one thin dime of income taxes, estate taxes, no taxes at all. You still pay the same taxes in all circumstances. What it does help is with avoidance of probate.
Gotcha. Okay. That makes sense. Now it's definitely a case-by-case scenario and where you are and what your situation is as to whether or not that's even a thing you should even consider. Okay. So when should I kind of create a will or a living trust, or when should I really make that decision? Okay, I need to get something on paper, because we neither know the hour nor the day when we're called. When should I start really considering creating something like that?
Yeah. So the will, everyone watching this podcast, I think, I'm trying to think of exceptions. There's probably an exception, but I would say that everyone watching this should have at least a will. You do not want to die intestate.
Yeah.
It'll create all kinds of issues for your family. And, unless you hate them.
Right. One last joke for everybody.
Exactly.
Yeah.
If you really want to stick it to them, just don't do anything. And then from wherever you are, you'll watch them and you'll see their whole life collapse, and you can feel happy about that. But that's a very negative emotion. Don't do that. Have a will at the very least. The next step up is the AB trust will with the Dynasty trusts.
Yeah.
That's important if you have certain assets. If you built up something worth organizing and leaving in some sort of formal way. And then the next step up from that is the living trust.
Yes.
Which is where you have a complicated estate, or you're spread out in different states. Or if you have a Brady Bunch family, also you may want to use a living trust for that. So there are circumstances where the living trust does fit. So it's kind of a progression of I don't want to say complexity, because then it sounds like you don't want to go there, but it's just depending on your estate and what your situation is.
Okay. So I created, and I should create one today. Like if you don't have one, go do it right now. Stop what you're doing. No, finish watching this video and then go do it. No.
Yeah.
How frequently should you review and look over that will? Because your circumstances are going to change.
Yeah, that's a very good question. You should review your documents at a minimum every 3 years, but that's kind of a very generic rule of thumb. I would say worst case scenario, every 3 years you should review it.
Yeah.
But there's a whole list of things that could cause you to go back and look at your documents. You change jobs, you have a new you get married, you get divorced, you have a new grandson, you have a new daughter. You move to a different state. There are, any kind of major change in your life probably should get you to say, I need to review the documents to make sure they reflect what I want to have.
Yeah.
And it's important that you do. I think I've probably looked at. I'm not an attorney, so I don't give legal advice. But over the years, I've seen, I don't even know, I'm going to say 5,000, maybe more, estate plans, and one of the most common things that I see is they haven't reviewed them in a long time, and they do not reflect, what they want anymore. And then secondly, what I see is that their life has changed, or the laws have changed, and what they have does not reflect those changes.
Right.
So you have a change in preference. Sometimes people want to leave more to one child than another, or they've changed their mind. Laws can change. Their life has changed. There's all kinds of stuff. So at a very minimum, you should look at it every 3 years.
Okay.
But in a lot of times, it's even more frequent than that.
Yeah. Major life change, you should look at it. Buying, selling property, take a look at it.
Exactly.
Yeah. If you move, you change your driver's license, take a look at your will. Put that on the list, right?
And it's just easy, because it's the last thing, that you want to think about is your own mortality.
Of course.
And so it's easy to not want to do that.
Yeah.
But trust me, you're doing your family one of the biggest favors by doing that. Because like I said, I've unfortunately run into many heirs who are dealing with the finances of their parent or their grandparents, and they're in no emotional state to deal with this stuff. Yeah. And you have to deal with it within 9 months.
Oh, yeah.
That's
quickly.
How much time you have. And 9 months sounds like a lot, but it goes by really fast. And if you're not, if you're trying to sort all this out and organize it and do what you think mom and dad wanted to have happen and all of that, you're putting somebody in a really difficult position.
Right.
And it's not fair to them. They want to grieve. They want to remember you. They want to do all that. And yet now they're having to deal with probate and taxes and this and that. Do them a favor. Yeah. It's an act of love.
I agree. Okay, speaking of mortality, on a darker note, power of attorney documentation and documents.
Yeah.
How should you kind of think about that? Again, when should you think about that? And then how should you?
So the power of attorney documents are something that I think that basically everybody watching this podcast should have. Okay. And I think it will too. Yeah. But the power of attorney documents are the ones where you give others the right to do things.
Right.
And those are super important because it's the right to do things while you are alive.
Right.
Okay. So in the scenario where, I don't really care because I'll be dead, right. That's your will. But this stuff is about when you're alive. Yeah. And so they affect you personally. So you have a selfish interest to have those documents. And there are several. One of them is what's called a durable power of attorney. Okay. So the durable power of attorney is where you give somebody the right to make financial decisions for you. Okay. So if you are incapacitated and bills have to be paid, investments need to be taken care of, property taxes, etc., you need to give somebody the authority to do that for you. And by the way, nobody has the authority to do that for you if you don't give them that authority. Yeah. Because otherwise, guess where they have to go? To the state. And they have to go to court to get that permission. Yeah. And that can be time consuming. It can be costly. And it could be very costly if bills are due or taxes are due or investments need to be done. And they're stuck waiting for the judge to give them the right to do that. Yeah. So the durable power of attorney is the one where you're giving somebody the right to make financial decisions. The second one, I call it a pull-the-plug document. Okay, yeah. And basically it's a physician's directive. Yes. And the physician's directive says that if 3 independent doctors deem that you are not going to make it, right, then they can pull the plug. Okay. And that is very important because we've all seen, where families are stuck in court for years trying to pull the plug. They're being drained of all their money, keeping somebody that's never going to make it, on life support. Yeah. It's costing them thousands and thousands of dollars. Right. And it's tragic. And you see this, I've seen it many times in the news. And if they had a, physician's directive, they could have saved themselves from the anguish, the costs, all of that. Yeah. It's up to your moral compass. There are people who don't want to that. It's, depending on their morals. There are some religions that don't allow for that. Mm-hmm. If that's the case, that's fine. But for most people, that's an important document. The other document that you should have is the medical power of attorney. Okay, so the medical power of attorney is the one where you give somebody the authority to make medical decisions for you, to authorize procedures that could be done, those kind of things. And again, don't think that just because you're married that your wife can make these decisions for you, or that your kids can just go to the hospital and say, operate on dad. Mm-hmm. No, nobody can do this stuff, right? Only you can authorize who can do this stuff for you. And so even your spouse does not have the right to operate on you, or all those kind of things, unless you've given them that authority. Mm-hmm. And so that's, don't assume that they have that. So you have to give somebody the right. And the thing about, there are different situations where you could have, let's say you have 3 kids, and one of them is just a genius with money. Mm-hmm. The other one is a doctor, right? So maybe you name the one who's a genius with money to be your durable, right? And you make the one who's a doctor to be your medical. Yeah, absolutely. So you don't have to have the same person have all the rights. Right. You could do it differently. Yes. Probably dating myself here, but I remember a Seinfeld episode where Kramer was trying to figure out who was going to have his medical power of attorney. And I think he named George at first, and then he was like, "You're going to kill me. I know what you're going to do. The moment I get sick, you're pulling the plug on me. I don't want you to be that anymore." So you have to pick. And then again, that's why you review your documents, because time goes on. Your kids may be minors right now, and you don't want them to have any of those rights. Right. But then later, you might, if they come of majority. So one child may be able to, but now they've moved to Hawaii, and so now they're not there, so they can't do that. So there are lots of additional reasons why you want to review your documents. Absolutely. So let's see, what have I? Okay, so then there's another document that most people don't think about, and that is the guardianship document. Okay. So the guardianship document is kind of like, if you had minor kids, you talk to your spouse and you'd say, if something happens to us, who's gonna change the diapers, who's gonna bathe them and clean them and medicate them and feed them and take them to school, and who's gonna be their guardian? Yes. Well, if you become incapacitated, somebody needs to be your guardian. Somebody's going to need to, it's terrible to say, but change your diaper, feed you, medicate you, and do all those things. Absolutely. And again, don't think that just because they're a family member that they have the right to do that. Yes. Now, they can do it, and probably nothing will come of it, but they don't necessarily have the right. Yes. And if there becomes an issue about it, then all of a sudden you've got a family war on your hands. This stuff is just easy to do to avoid all the complications that could happen. Yes. Now, hopefully none of them will, but they could. So the guardianship document is where you say you give authority, power of attorney, to someone to take care of you if you can't take care of yourself. Your activities of daily living, as they're called. So those are the power of attorney documents. I think I've covered them all. Yeah. But those are very, very important, and they're not expensive. Yeah. So that's the thing. Yeah. Get it done. Yeah. There's not a good excuse to not having it done. No, there isn't. And it's a little bit of your time, and you have to kind of think about your mortality. Yes. You have to think about your morbidity. Morbidity is the stuff we've just been talking about, where you become incapacitated. Those aren't pleasant things to think about. Yes. And I know that, and that's why people don't do it. Yeah. But the fact remains that if you don't do it, they're going to have to do it for you, and it's not fair to them to put them in that position, again, because they're not in the frame of mind. They're not going to make proper decisions when they're in the emotions of that moment. Yeah, yeah. And on a lighter note, you don't want the state stepping in either. No, you don't want your family to have to deal with estate.
Yeah. Yeah. No, nobody wants to deal with it.
Yeah.
You don't want to deal with them,
No.
so your family sure doesn't want to.
No, they are not your friend.
No.
The state is not your friend.
No.
You know, I'm not saying they're bad guys, but they're not your friend either.
Right. Yes, absolutely. Okay, I think that pretty much covers our the basics of estate attorney. I think this is a good start to our series. Anything else you want to add?
No, that's the beginning. So this is a series, right? And so the next one we'll talk about is beneficiary designations. And, a lot of people, when they create their beneficiary designations, there's a lot of things that they don't understand about the ramifications. And, we'll talk about why, in many cases, you do not want to name your spouse as your beneficiary. You don't want to name a trust, a beneficiary of your IRA. There's lots of little intricacies, I'll say, about beneficiary designations. It's not just as simple as this is who I leave it to and this is the percentage. There's some things you need to understand and before you make those decisions, and we'll do that in our next podcast.
Perfect. Awesome. Well, thank you, Ken.
Thank you. So, ladies and gentlemen, thank you for watching. Please like and subscribe to this. Share it with your friends and family as well. That would be great. And I hope you found this interesting and, most importantly, entertaining, because this is really boring stuff. If we made it entertaining for you, then hopefully you learned something in the process. And we'll look forward to talking to you soon. And I hope this video found you healthy, wealthy, and wise. Take care, everybody.
Retirement Planners of America, RPOA.com.